All right. And so now I will say the purpose or goal of our committee is to gain a better understanding of the strengths and weaknesses of the criminal justice system of San Diego County and advocate for best practices. And I am pleased to introduce Judge Ana España. Is that how you pronounce it, España?
Yes, España.
All right. And she received her JD in 1982 and started work at the Defenders Incorporated, where she represented children and parents in child welfare proceedings, as well as children in delinquency proceedings. She was recognized as one of the state's leading child advocates, and in 2011 was awarded the honor of Outstanding Legal Advocate by the National Association of Counsel for Children. She was appointed to the bench by Governor Schwarzenegger in 2008 and continued her advocacy work by, among other things, establishing a behavioral health calendar in the South County Division in 2015, where she served as supervising judge. She returned to juvenile court in January of 2018 and currently serves as presiding judge of the juvenile court, which includes both the delinquency and dependency divisions. So we are honored to have Judge Ana España, and how should we address you? Your Honor, or Judge España?
Either, that's fine. Thanks so much.
Right. Thank you, Your Honor.
Really do appreciate the opportunity to be here, and it's good to see former Judge Sontag, Stephanie, to be part of this group as well. Good to see her, and nice to meet all the rest of you. So what I was asked to do was just really talk about some recent developments in juvenile justice reform. So I'm gonna put up a from the beginning, and let me see, do a what I want to do is I need to move something to get, I want to play slideshow, but it's this little area. Oh, there we go. I move it slideshow from the beginning. There we go.
There we go.
Got it? Okay.
Got it. Thank you. Technology, isn't it fun?
Oh my gosh. Well, I'll tell you guys, this is like the second time I have now screen shared after all these years since COVID. So I think I'm finally getting it. So yeah, so I was asked to talk about recent developments in juvenile justice reform. And first, just want to say that the job of the juvenile court, mission of the juvenile court is really fairly complex. The court is, of course, tasked with protecting society and safeguarding our youth and families that come to its attention, and holding delinquent youth accountable while at the same time supporting their rehabilitation. So there's been a lot of discussion in recent years about adolescent brain development. We'll talk a little bit more about that in just a second. Trauma among justice-involved youth, diversion programs, the length and conditions of probation, the use of confinement, the return of long-term commitments from the state to county supervision, transfer hearings to the adult criminal court, and race ethnic equity within the juvenile justice system. So there has been, again, a lot of discussion nationally and within our state regarding juvenile justice reform, starting really in 2005, where the National Council of Juvenile Family Court Judges worked with the juvenile justice courts to develop and distribute best practices in juvenile justice proceedings. In 2016, judicial officers from across the country participated in a roundtable seminar convened by the Anna E. Casey Foundation, and conclusions from that seminar informed the 2017 resolution regarding juvenile probation and adolescent brain development, which really called for a shift in how juvenile court systems should supervise youth on probation. It called for systems to organize the probation experience around individualized case plans, developed in partnership with the young person as well as the family, with the ultimate goal of promoting behavior change and success for the child. In 2018, the council enhanced its juvenile justice guidelines Much had changed since 2005, from the landmark Supreme Court decisions that ended the death penalty and solitary confinement for juveniles to changes in practice, all really as a result of the study of brain science. In 2019, the council again convened a panel of judges to look more closely at the role of judges in transforming juvenile probation, and developed a toolkit for juvenile judges across the country on how we could participate in doing just that. There's a number of organizations which have been urging juvenile justice reform, from the Annie E. Casey Foundation to the Council of State Governments, Georgetown Center for Juvenile Justice Reform, the Urban Institute, the Stoneleigh Foundation, and others. And in California, the study of adolescent brain development and trauma has been very much a part of juvenile education for our judges who wish to preside over juvenile justice cases. So this is our juvenile justice primary assignment orientation, just an example from the table of contents, which really causes us to focus a lot on adolescent brain development. And I have to tell you, it's since really 2005, this study has just really exploded and helped to influence and inform juvenile justice practice. We know now that behavioral and neurological evidence show that youth are still developing their ability to regulate their behavior, to consider the consequences of their actions, and to resist peer pressure. So we know now that brains do not fully mature until age 25. So as I said earlier, the US Supreme Court and other legal entities has utilized this brain science to reform juvenile system policies and practices concerning adolescent offenders. Again, prohibiting the death penalty for juveniles in Roper v. Simmons, prohibiting mandatory life without parole sentences for juveniles in Miller versus Alabama, and JDB versus North Carolina, requiring officers to consider the age of the youth for Miranda warnings. The other, again, piece of it that we have really been studying a lot is trauma and the justice-involved youth. What we know is that, frankly, the vast majority of our kids who are in our juvenile justice system have been impacted by trauma in some way, whether it be by community violence or family violence, death of relatives or family members, even in their incarceration. And so we really are learning now with adolescent brain science and with the knowledge that these kids have been impacted by trauma, what are the things that we can do best and how can we respond best to their needs? So there's been, again, the recent focus on transforming juvenile justice. There was a 2020 study tracking 5-year outcomes of over 1,000 young people who were arrested for moderately severe offenses, and found that the youth who were formally processed, that means coming into the juvenile court system, were more likely to be rearrested, to be incarcerated, engage in more violence, greater affiliation with delinquent peers, lower school enrollment, less likely to graduate within 5 years, less ability to suppress aggression, and lower perceptions of opportunities than formally processed youth. Recent studies have also found that the surveillance-oriented probation is not an effective strategy, really, for reversing delinquent behavior. And it's inconsistent with what we know now about adolescent brain development and science. There's insignificant effects on recidivism, and especially poor results for youth at low risk of rearrest. So holding youth accountable, we're learning now, does not always require punishment or a punitive approach, and should not be reduced to a list of rules or behavioral conditions. Instead, rather, challenging young people to dedicate the time and energy to individualized programs of self-improvement. And so that is what we're really been focusing a lot here in San Diego most recently. So what does work, and what does the science and the studies tell us that works for kids? Are behavioral and therapeutic supports and interventions like ART, which is aggression replacement therapy, or CBT, which is cognitive behavioral therapy, DBT, which is dialectical behavioral therapy, functional family therapy, multi-systemic therapy, and WRAP services. So I am a big fan of these. And when kids and families are assessed and need these kinds of behavior supports, then I order probation to make sure to get these kids linked to these kinds of programs. We know that restorative justice practices work as well. And partnership with families. I mean, parents and family members still remain the most important people in the young person's lives, and we need to learn to engage them more. What we know works also is partnership with community. Credible messengers, again, big fan of those persons who have had the life experience that our kids have had, who've now outgrown that life and become now valuable members of our community and coming back now to mentor young people. We have those now employed throughout our institutional program because we find kids listen more to persons who have lived the life that they have lived. We know that life skills and employment-focused programs help. Positive youth development activities help. So for all of my kids, I just made an order today that I want probation to help make sure that the youth is involved in pro-social activities and support the youth search for jobs and job training, because we know those are the kinds of things that can help young people rehabilitate and lead a more successful life. We also know for adolescents that incentive work as well. And so what are the things that we can do to help incentivize kids to successfully complete probation? And we have to expect setbacks. Again, they are adolescents, young adults whose brains have not fully developed, and we have to expect that, and we have to be able to respond accordingly, but to really look at these as options first before we look at incarceration. So let me talk just for a moment about diversion. A big fan of diversion, and our council has urged us to ensure that our systems divert cases to alternative systems whenever possible and appropriate. And so in San Diego, we have our law enforcement agencies, the vast majority of them have programs that they do divert young people to. These are low-level offenders, obviously from infractions to low-level misdemeanors. We don't want those kids involved in the juvenile justice system. They tend to be low-risk kids. They need to be diverted out in the community. And there's a number of studies which tell us that youth diverted from court have less future contact with the justice system than comparable youth whose cases are formally processed in court. So we know diversion works. We know that it's in the best interest of particularly low-risk youth. Unfortunately, few local jurisdictions invest in diversion programs. Like I said, in San Diego, we're lucky to have our law enforcement agencies have diversion programs. What we have, and we're very fortunate, I just had a meeting with Summer Steppen and other leaders yesterday on the San Diego District Attorney Juvenile Diversion Initiative. I think San Diego's DA's office may be the only one in the country that has opened a diversion program, because only prosecutors can divert felonies. Right now, under California law, our felonies must be referred to the probation department. And there is no authority for the probation department to divert those people or young people charged with felonies, but the DA's office can. And so we have had now the DA diversion program for a better part of a good year. They're still really honing their work. We find that of the families that reject the ability to divert, half of the reasons for 50% is caregivers declining participation in the diversion program. And so we're really trying to figure out that, is it, are there cultural reasons for that? For example, I mean, is there a reason, maybe understandably so, that some families distrust the district attorney's office and doesn't want anything to do with diversion, even though at the end of the day, if their child successfully completes diversion, their case filings would be sealed. So we've talked with Summer Steppen and others about really doing a deep dive on why caregivers are rejecting the diversion program. But we've had many kids successfully complete those their diversion program, and their arrests are sealed. For those kids who fail out of diversion, then the district attorney will file their matter in the juvenile court, and then we'll handle it accordingly. And we really try to promote race equity through expanding the use of diversion. There's been strong research that shows that youth of color, especially our Black youth, are far less likely than their white peers to have their cases diverted from the juvenile court. And so by expanding access to diversion and track data by race and ethnicity, we can help ensure that youth of color are benefiting proportionally from expanded use of diversion. So a lot of work that still needs to be done there. But again, in San Diego, we're very fortunate to have the DA's office sponsoring a diversion program for us. Again, there's other ways to divert. So we're always trying to do prior to arrest, as I mentioned, at the prosecutorial level, as I just mentioned, with the DA's office. And once the juvenile petition is filed in our juvenile court, there's opportunities for us as judges to also divert kids away from the formal wardship and probation. One of the ways is informal supervision. And I'm very proud to say that our juvenile court judges of California sponsored a bill last year, which expanded informal supervision as an option by deleting certain restrictions so that we could have more youth and we can consider more youth for the informal supervision program. There is non-wardship probation, which provides a formal structure without judging the youth of putting these formally on probation, restorative justice practices, which I really love. It's victim offender mediation. We send kids to victim impact classes. And if they do that, then we'll dismiss their petition. And deferred entry of judgments, which requires the youth to admit all the charges, but then defers entry of judgment, and that's placing them on probation. And if they do well, that results in sealing their case. So again, very much wanting to continue to build on this so we can divert kids whenever possible from entry into the formal juvenile justice system. One of the things I'm most excited about, and working with the juvenile court judges to help work on legislation to mandate this across the state for our juveniles, is case planning. Now, right now what we have and what's the typical practice is putting kids on probation and then giving them a list of things that they cannot do. And actually, I should have had my other slide on conditions before this one, but that's the practice of it now. Probation is required to case plan for kids who are in foster care, just like on the dependency side of our house, the child welfare side, we have case planning on that side. On the juvenile justice side, case plans are required for kids in foster care. And probation will tell you that they have case plans for all kids. But it's not the case planning that I really am promoting and which really the studies are showing are most effective. And that's individualized case plans based on an identified risk and needs assessment that's strength-based. So what are the things that we can put in place that will help support the youth's success and really building on the strengths of the young person that's before the court? Obviously, it's got to be trauma-informed. As I indicated, the vast majority of our kids have been impacted by trauma. And case plan should include the relevant services, whether it's therapy, behavioral support, or pro-social activities. It needs to involve the youth and the family in developing the case plan, and family in this instance is interpreted quite broadly. It needs to offer graduated responses and meaningful incentives to our kids. Again, kids, teenagers like these incentives. I mean, we've even talked to probation about getting gift cards and working on baby steps towards success with these incentives. And the big incentive I talk to kids about all the time is successful completion of probation, which in most cases will result in sealing of their juvenile record, which is what they want so that it doesn't get in the way of their future in terms of jobs, things like that. And of course, case plans have to recognize the needs and interests of our victims, right? And really embrace restorative practices. Now, here's the case conditions of probation piece. Again, our focus in San Diego, we're going to do some more training in June or July rather with our probation department to focus on developing a case plan and really minimizing the number of court-ordered conditions which kids could be violated on. There was one Center, the National Juvenile Defender Center brief that found that in some jurisdictions, kids have to manage over 30 conditions of probation, which is a near impossible number of rules for kids to understand, follow, or even recall. In San Diego, 2 years ago, we took what was about 20 plus conditions of probation, if not more, and whittled it down to 7 basic conditions of probation for every kid. Like, don't violate the law, go to school, don't violate curfew. Some of those are required by our current statutes, very basic conditions. And there's others that are very specific, like for kids involved in gang, and we have specific conditions for them with regard to that. But really try to minimize the conditions and really focusing more on what are the things we need the youth to do to be successful, and focusing on case planning. When there's a failure to comply with probation conditions, we're really trying to move away from the sanctions of custody, for example. Too many youth were confined for technical violations of probation. And so we're really looking at referring to community services and support. So the youth is still smoking too much marijuana, or still, running amok in the community at all hours of the night. Well, we've created what we call achievement centers, located throughout our county, where we have mentoring, tutoring, counseling. We even feed them dinner. They could do community service work there. So there's opportunities for kids to get referred to the achievement centers rather than putting them in custody. So we're trying to do all that we can to help kids be successful out of custody. And really the kids that come into custody should be ones who have committed serious violent offenses. And that's the population we need to focus on in public safety, right? For kids who are violating the terms and conditions of their probation. And, we have to think about the way kids think. Again, as I said, regarding probation conditions, I'm trying to remember a long list of conditions. It's hard for kids to think about long-term goals. So we really have to look at those short-term goals of success. So sometimes we'll set hearings very regularly just to give the youth a goal. I want you to go to substance abuse treatment. I want you to enroll. I want you to attend for 6 weeks and come back and tell me what's going on, that kind of thing. And we do have to consider how conditions of probation might have a disparate impact on youth of color, considering how blanket conditions prohibiting youth from associated with entire class of individuals based on their current or past involvement in their justice system, remembering where some of these kids come from as well, in the communities they come from. So we have to really consider all these things. I know we had a couple of kids, because we really are moving away from these probation conditions, but before, we'd have kids saying, well, wait a minute, but my cousin lives in my neighborhood, and yes, he might be a gang member, but he's still my cousin, and we have family gatherings. And so I'm not to go to the family gatherings because my cousin and maybe the uncle might be involved in gang. So we have to be very thoughtful about the conditions that we impose. And again, at the end of the day, what are the things that we can do to help strengthen our kids, to help them be successful? Length of probation is another thing we've been talking a lot about. The Annie Casey Foundation in Transforming Juvenile Probation says the duration of probation should be individualized. We've had kids on probation. We did a study last year and just evaluating that up to 4 years. And we have to really look at why. The duration has to be individualized. The Casey Foundation recommends typically probation would be roughly 6 to 9 months. The Pew Charitable Trust Public Safety Performance Project has recommended shorter terms of probation for youth in several states, and this was in 2017. And we need to build incentives for shortening the probation terms as rewards for positive behavior, and that can help improve outcomes and reduce costs. So AB 503 was a bill that we supported as judges, and it would require hearings every 6 months and for the court to consider termination and be a presumption in favor of termination unless there were certain specified factors that the youth is still violating, and that there would be a need to continue the youth on probation. And unfortunately, it was vetoed by our governor, primarily because our probation departments and our courts are very much involved in the realignment of juvenile justice that we'll talk about in just a moment. But what we did do in San Diego, based on 503 and what we were hoping to gain from 503, the County Board of Supervisors directed our probation department to set review hearings every 6 months. Before that, it was annual reviews. You know, the only time we would see a youth is once a year, or if the youth committed a new crime, for example, obviously we see the youth again, or the youth was violating probation, or there was some special need that the court had to address. So now we review kids' cases, kids who are on probation, every 6 months. And at the time, probation writes a report and will tell us how the youth is doing. And if the youth is successful on probation, then we can terminate at that point. The other thing we've been spending a lot of time on is the use of confinement, and it should be only for those youth who have committed serious offenses and who are an immediate and significant threat to public safety. And as I said before, we have to eliminate incarceration as a response to technical violations of probation. And why? Studies tell us that even brief stays in custody can harm young people. And there are, again, severe racial and ethnic disparities. Youth of color, youth of color, particularly black and brown youth, are far more likely to be detained than comparable white youth. And then detained youth are far more likely to receive more severe dispositions, that's sentencings. So we really need to look at the kids that we are putting in custody. There is a process locally for us to make, for them, probation, to make that evaluation and to refer kids out into the community if the kids don't meet certain risk factors. And so there's a stress and tension between law enforcement agencies and probation, where law enforcement may want the youth to be placed in custody, but the youth doesn't meet the criteria for custodial response. And so we're still trying to tease some of that out. But I'll have to say, during COVID, we were down to about 130 kids at our institutions, and we are now at about 250 and growing, unfortunately. The one other thing to consider is that, and this is something that I think about a lot when I'm handling the kids in front of me, is that even among youth who are adjudicated for serious offenses, 91% do not continue to offend at a high level 3 years after their initial adjudication. And about 3/4 report very low levels of offending or none by their mid-20s. So getting arrested for any single offense, no matter how violent, is not a strong predictor of future arrest or adjudication. But what is a strong predictor are the presence of multiple risk factors, the absence of corresponding protective factors in multiple domains, and that's with individuals. So, you know, we see, unfortunately, a lot of youth who have these multiple risk factors, substance abuse, poor peer interactions, and fragility within the family structure. I can't tell you how many parents I talk to, and I try to be, again, trauma informed, because most of our families themselves have been impacted by trauma, but really wanting parents to be parents and supervise their kids. And now I just talked to a parent yesterday, not let his kid go on sleepovers. When we know now when he's on sleepovers at other friends' house, they're out in the middle of the night stealing cars. I mean, so he can't go on other sleepovers for now until he grows up. You know, and it's these kinds of conversations I have. But, you know, the mother's in the hospital, she has health issues, the father's, you know, working full time and not home. And it's these kinds of things that we really have to work to strengthen, again, to help support the youth and his family. So what's been happening most recently has been juvenile justice realignment. So for kids who were committed for violent offenses, typically murder, rape, attempt murder, manslaughter, those kinds of things, typically would be sent to the California Department of Juvenile Justice. And that's a state system. And it's in Los Angeles and other parts of California. So the governors decided to realign that work And now we'll close that entity. So DJJ will be closing at the end of next month. And instead required the counties to establish a framework for a local secure track of facility. We're calling SYTF. In San Diego, it's called the Youth Development Academy. And so it's taken the kids who committed these offenses, who we'd sent off to the state, and we wouldn't see them back for years until they re-entered, now is requiring each county to build within its county a local, sort of a little local prison. And again, it's called Youth Development Academy. It's for kids who are 14 and older, who are adjudicated for an offense that could result in a DJJ commitment. The baseline term of confinement, let me just give you an example. So for a kid who commits murder, let's say, on the adult court side, that youth might face 15 years to life, perhaps 25 years to life. In juvenile court, the baseline term of commitment is 7 years. And come July 1, that's even going to change to a range of 4 to 7 years, just depending on the facts and circumstances of the particular youth. Also, this legislation expanded our juvenile court jurisdiction. So again, before we'd send these kids off to DJJ, we wouldn't see them. Before we had jurisdiction up to age 23, and they'd keep kids really up until age 20, 21 and send them back to us, and we'd supervise them maybe for a year or so. But now our little court now could extend up to age 25 or 2 years from the date of commitment, whichever occurs later, if the youth in the criminal court would have faced an aggregate sentence of 7 years or more. So that could be like a murder case, a voluntary manslaughter case, things like that. And so now we in our court are having to learn to, and our probation department, particularly because these kids are in custody locally now, have to learn how to handle not just teenagers, but young adults as well. The law changed as a result of SB 823 to require to lower the maximum term of confinement to the middle term of imprisonment that could be imposed on an adult if convicted for the same offense. It requires that the court develop an individual rehabilitation plan. And that's sort of like the case plan for the youth in custody now. It's got to be developed in consultation with a multidisciplinary team, and it's got to address the youth's needs with the programming, treatment, and education interventions will be obviously trauma-informed, evidence-based, and culturally responsive, and have youth and family input. So I am right now in the process. We've got about 35 kids who are DJJ. We've brought back about 17, 18 of them. We have to bring them all back by the end of June. And so I'm in the process right now. I'm the court where those kids are re-entering from the state jurisdiction to us locally, and I receive them and send them back to their home departments, but order that an individual rehabilitation plan be developed so that the court and all the justice partners, the district attorney and the defense attorney, knows what are the services that are going to go into place to help rehabilitate this youth. And so we're in the very beginning stages of this process as we start to bring these kids back. And then we have to have progress review hearings every 6 months. We review their plan. The kids can earn, remember incentives work? Kids can earn a downward deviation of their baseline term of up to 6 months. So every 6-month review, the court can consider downward deviation, have less time in custody if they're doing well. The court can also order youth to a less restrictive program in the community as part of their commitment. And then this law provides for a probation discharge hearing, and then violation of the probation post-release, they can come back to the juvenile facility if in fact they are violating probation pretty significantly in the community once they're released. And then lastly, transfer hearings. Whether or not to transfer youth to the adult criminal court is the biggest decision really for the kids that are active in the juvenile court system. As I gave you the example of murder, right? So kids are transferred to the adult court on a murder charge. Potentially we're talking about 15 years to life in prison, whereas juvenile court right now, the baseline is 7 years. Big difference in how we treat kids. So it's a very important decision, not only for the kids and their families, but for our victims as well. So prior to the year 2000, youth were entitled to a transfer hearing. There was criteria to consider, much like the 5 criteria that I've outlined here in the slide, but there were presumptions against fitness. So my husband was a defense attorney for juveniles. He did this for over 30 years. And it was very much a very stressful experience for him because there were presumptions against the youth, depending on for example, the severity of the offense. And so he had to overcome all these presumptions against fitness in order to be able to successfully keep a child in the juvenile court. And then in March 2000, the prosecution was authorized to file the action directly in the adult court for kids who were 14 and older. And so my husband had the first 14-year-old who was charged as an adult. That law continued to exist for 16 years. So DA's office can bypass the juvenile court and say, I'm going straight to the adult court. I'm going to file the criminal complaint there. And then Prop 57 in 2016 amended the Welfare Institutions Code to, okay, hold on, come back, to require transfer hearings for a 14-plus-year-old child before a child can be prosecuted in the adult court. So once again, requiring the juvenile court to be involved in those decisions. And then in September 2018, the code was further amended to now require kids to be at least 16 and older at the time of the offense in order to be transferred to the adult criminal court. And the court has to consider this 5 criteria that I have listed out. And the most recent change to the transfer hearing is the burden of proof. Before, the district attorney had to prove by preponderance of the evidence that the youth is not amenable to juvenile court intervention. Well, now the burden of proof is clear and convincing evidence, and that's a much higher burden for the district attorney's office to meet. And I can tell you anecdotally, I've been finding, because probation now has to also evaluate these criteria with that higher standard, and probation is making more recommendations to keep kids in juvenile court, and judges are making more of those decisions. So, you know, it's just an interesting evolution on how we look at kids and how we respond to kids' issues when they come before the court. And you know, we also know transfer orders and their impact on youth of color, too, is something that we always need to consider when we have these cases in front of us. So that is a summation of our juvenile court reform efforts and what's happening here. So I have a couple of minutes before I need to step on the bench. I'm happy to answer any questions you might have.
Well, I'm going to jump in and ask one quickly, that our community has been looking into police in schools and how many students are getting arrested in schools for offenses that previously would have been, you know, sweep up the school after, you know, or, anyway, minor things that the principal would put on. And I'd be curious what you see, how many come from the schools. Also, you've mentioned the students of color, but a lot of our research is also talking about the disabled students who are being affected. Do you have any statistics on that? There are statistics for kids who had disabilities and what their impact has been. I could tell you that there's discussions about policing on school grounds, and that wouldn't it be better instead to maybe have social workers, you know, on school grounds to help address some of the challenges the kids and families have and make appropriate referrals to services. There's been a lot of discussion about that and a move away from law enforcement because of that worry, that pipeline to prison, starting with law enforcement in the schools. I think for us, most of the crimes that we're seeing now in the juvenile court are serious violent offenses. So I'm not seeing, so even if some of that's happening, I think those are being either diverted out ultimately or diverted by the district attorney's office. But that's a real concern that you raise. And I know one that is definitely, I think we're still talking about. Okay, thank you. Thank you. Any other hands up? Questions?
Mm-hmm.
Stephanie, and then Simone.
Okay, it's just amazing all the changes that have been made. That's incredible. I was wondering about resources for not diversion, but some of the therapies, CBT and that kind of thing. Do you have enough resources to counsel the kids that need that therapy?
Not as much DBT as we would need. And I'll tell you, I just had this conversation yesterday because I think our county still needs to do, our probation department needs to do better, and even linking kids to therapeutic supports in the community. In the institution, they're getting CBT and DBT. They absolutely are. And in some of the group homes now, we see more of that coming up and being available for our kids, but definitely not enough. Definitely not enough. There's wrap services, which I am a big fan of, because these are services that wrap into the home. The parent has a partner, the youth has a partner, and they really help bridge those communication challenges within the home. We have really good services there for that. But there's still more work to be done. The other good thing I have to say is that behavioral health services has been getting a whole lot more money and resources from the state. And so that's a good thing. And the federal government has been sending more money to the state as well to help and enhance and support prevention services. And so we're coming in a couple of years, probably by the time I retire, where we'll be really good to go. But in the meantime, there's still a little struggle. And one thing I did want to mention to your membership, one way we really could use support is our people becoming members of the Juvenile Justice Commission. And these are volunteers who really work to review the institutions and group homes and making sure that our kids are getting what they need, and writing reports that are published, and that comes to me too as the presiding judge. And so it's a Juvenile Justice Commission, San Diego Juvenile Justice Commission, and you just look them up, you Google it, there's application there. And if you know of folks who you think would be a really good fit for that work, please do really encourage their application. We need good, strong applicants.
That's very good to know. Simone?
Yes, well, I know that you work more closely with those who have crossed the line. And a lot of us are really trying to work with people who aren't there yet in that direction. I'm a former teacher, and I worked with a lot of students who had records. And what I noticed was a couple of things. One was self-image that they had. And so you seem to be talking about how things are being put in place now. But also, I think incentive is money. I remember a student where I was subbing at a school just a couple of years ago, how he was just really proud of himself that he bought his mom a house by selling drugs at school. And, and so I'm just wondering what kind of partnering needs to happen to catch them in a practical way, so that isn't a choice they make, which I understand why they make that choice. I don't agree with it, but I understand why things go in that direction.
Right. It really is. I just met with he's a former National City Police Department detective, and now works as an investigator in the DA's office. And he once, his family life was impacted by gang violence, and so he's looking to build programs within schools to create mentoring and incentives. And he talked too about money. A kid needs to buy his mother a pair of shoes or whatever. And so he knows how to sell it. He was using that exact example, and instead, offering a $50 gift card, but, spend some time with this mentor. So I think we really, I was talking to him about this, we really need to drill down in the schools. And really, the younger, the better. To try to be able to impact these kids, because what he said to me, and it just kind of hurt me, but it's true. He says, by the time they get to you, Judge España, it's almost too late. And we keep struggling and trying very hard to help these kids, and we see some successes for sure, but he's right. Really, you need to go upstream quite a bit and really get kids involved in pro-social. Like if they can't afford a soccer uniform, is there a way to get that soccer uniform so they can participate on that soccer team? we have a lot of families who just can't afford, or the kids are end up babysitting because the parent has to go to work and the kid can't go to school or can't, there's just so much that needs to happen early on with these kids and families. And I think that's the direction I know we're going with some of the federal funding coming from what's Title IV funding. It's prevention money for at-risk kids and families. But, I don't know that it'll ever be enough. And so it's volunteers in the schools to be able to reach out and connect to kids who are at risk and really try and incentivize them to do something positive in their life. And I tell kids all the time, I said, the whole world is in front of you. You can be anything you want to be. I mean, what do you like? I'll ask the kid, what do you like to do? Well, I like to draw. Well, then, you could be an artist. You could be a graphic designer. You could, and it's like these kids who don't think about those things because maybe the world around them doesn't think about those things and those opportunities in life. And so it's getting those kids exposed to those pro-social and those mentoring by people who are positive in their life. There's something that says, there's a saying that is, one person can make a difference in the life of the child. And that's so very true. And I've seen it happen. And so whether it's, the Juvenile Justice Commission, as I recommended, or the court-appointed special advocate program, becoming a CASA, becoming a mentor, for kids, working for the Choice program, which is a mentoring program. I mean, there's lots of things that could be done where you could just make a difference in the life of a child. So I appreciate the question, though. Yes.
Yeah. Thank you. Do you have time for one more question?
Sure. One more. Yes, I do.
Yeah. All right. Well, there was an article in the paper recently about that the money that the state is requiring this change on June 30th. And yet the money to build the places just came through or something. So do you know where San Diego is? Will there be a place available for them?
So there is a place available. And the article in the San Diego Union Tribune was about San Diego. I will say one thing for probation was this legislation. I mean, it takes a long time to change culture and practice. And we're talking about the need for facilities, right? So now these kids at the state level are coming back to San Diego. We have to put them somewhere. And so right now they're going to East Mesa, which looks like a prison. It feels like a prison. And it was built at the time when there was a concern about the super predator of these kids, there was this time I was an baby attorney back in that day. And I remember them building this prison for these kids. That's the facility we have. We have a new facility built right next door to me now for, that's beautiful. Looks like a Las Colinas. If you've ever been out there, looks like a junior college campus. But these kids, the kids that the article's about are being housed in East Mesa. And they just really weren't prepared for it. But that's true with probation departments up and down the state. So it's a little unfair for a probation department to get kind of criticized in that way. So they're softening the units to make it more than just a concrete cell, right? They're softening the units, make it more, because kids are going to be living there for years. And our probation department's not used to that, taking care of kids for years. And the programming is starting to come in place. There's definitely some there now, but we expect them to be pretty fully operational with some really good programming by June. So it's just around the bend. But there's been a period of months where there was really very little there. And so that was what the article was about. And, I can tell you that the providers, it's used to call South Bay Community Services. They're called SCBS, something like that. They're awesome. They were the best provider to choose. And so I have full faith that they'll be able to really build a program there that will be restorative and rehabilitative. One thing, though, that no one's talked about yet is like, okay, there's a class called Thinking for a Change, which I actually sat when I was down in South Bay, and I went over to Donovan and I sat in that class. It was for adult offenders. So it's like a 10 or 12 week, 1 hour program. So we make all of our kids go through that. Okay, well, they have 4 more years of staying in our institution. So what next? What do we do next? So they have to figure out the programming, the plan for that for kids who are going to be there for long term. What I told them is that I want all of my kids to get college, either college or degrees. It could be a junior college, but college degree or a vocational certificate. And I want all of them to have access to jobs. And so we want to, because I want to give them the best that we can give them, since now we've got them back and we have control. And so they're working on that now. We have County Office of Education, which has been great. We have kids who started college virtually at DJJ who are continuing college classes virtually. We're hoping for some in-person, like getting Southwestern Community College out there and provide some in-person classes for kids. It'd be great. For them to be able to leave, and they leave with a college degree or vocational certificate, if that's what they choose, and a job, then I'll feel like they'll have the best chance that we could give them, So we'll see. Still, the jury's out on that. But I really appreciate the opportunity to share with all of you, which is my passion here, and as Stephanie knows, is when I came back to juvenile court, again, my work was here for over 20 years. And then I came down to South Bay for a while and do the adult criminal cases. And when I came back here, I tell her, we want to come back home now. This is where I grew up as a young professional, and I'm glad to be back here in this role.
Well, thank you. We're very glad that you did come back and that you did come and share your insight and